and welcome. I am Taniya Pandey and you are watching Courts This Week on LiveLaw, where we bring to you all the latest legal developments. So don't forget to subscribe to LiveLaw and click the bell icon for regular updates. As usual, let us begin today's episode with the Supreme Court judgments. The Supreme Court on 11th June directed the All India Institute of Medical Sciences to postpone the IGST 2021 exam, which was scheduled on June 16th by at least a month in view of the COVID-19 situation. A vacation bench of Justices Indira Banerjee and M.R. Shah was hearing petitions challenging the conduct of the National Importance Combined Entrance Test and seeking directions to postpone the exam being conducted for admission to postgraduate courses in leading government medical institutes in the country, including AIIMS, JIPMER and NIMHANS. The bench observed that considering that the candidates had been rendering COVID duties far away from centres chosen and inadequate time for preparation, they were of the view that fixation of date on June 16th was arbitrary. The Supreme Court on 11th June allowed as an interim measure that buildings devoid of building use certificate and an NOC from the fire department may continue to be used as hospitals and nursing homes in the state of Gujarat. The vacation bench of Justices Hemant Gupta and V. Ramasubramanian was hearing the SLP against the June 5th decision of the Gujarat High Court, dismissing the plea challenging notices issued by the Ahmedabad Municipal Corporation for sealing of hospitals run by the petitioners for lack of NOC from fire department of the corporation or building use permission. The genesis of the notices lies in a fire which took place in Shrey Hospital, Ahmedabad, which led to the loss of 8 lives. While a PIL in this matter was filed before the Gujarat High Court, the AMC issued a public notice on 22nd February 2021, stating that it was necessary to obtain building use permission and fire NOC before occupying any premises. Observing that the court cannot pass directions for financial relief, the Supreme Court disposed of a writ petition which sought financial relief in the form of a fresh loan moratorium, extension of time period under the restructuring scheme, and temporary cease on the declaration of NPA by financial banks in the wake of the COVID-19 pandemic. A vacation bench of Justices Ashok Bhushan and M.R. Shah observed that it is for the government to assess the situation and take appropriate decisions. The bench pointed out that in the judgment, Small Scale Industrial Manufacturers Association versus Union of India, the court had refused to order loan moratorium extension, and the same principles are applicable to the instant case as well. The Supreme Court refused to entertain a writ petition filed by former Mumbai Police Commissioner Parambir Singh, challenging the departmental inquiries initiated against him by the Maharashtra government. A bench of Justices Hemant Gupta and V. Ramasubramanian granted liberty to the petitioner to withdraw the petition and raise his contentions before the Bombay High Court. Although Senior Advocate Mahesh Jethmalani made elaborate arguments for Parambir Singh, the bench was not inclined to entertain the matter. The Supreme Court has directed state governments and union territories to ensure that there is no break in the education of children who have become orphans or lost one parent due to the COVID-19 pandemic. The bench has also passed directions to the states or union territories to continue the uploading of information of children who lost parents in COVID in the national portal of the National Commission for the Protection of Children's Rights in the suo motu case taken up to consider the problems affecting children during COVID. Taking note of the deposit of Rs 10 crores compensation made by the Republic of Italy, the Supreme Court on 11th June reserved orders on the application filed by the central government to quash the criminal proceedings pending in India against 2 Italian Marines with respect to the 2012 sea firing incident near Kerala coast, which killed 2 Indian fishermen. In July 2020, the Permanent Court of Arbitration under the United Nations Convention on the Law of the Sea had ruled that India was entitled to claim compensation from Italy for the death of Indian fishermen. However, the International Tribunal also held that India has no jurisdiction to launch criminal prosecution against the Marines as they had sovereign immunity. Following that, the court had directed the Republic of Italy to to deposit the compensation amount in terms of the award of the International Tribunal. The Supreme Court has directed the removal of all encroachments on forest land within 6 weeks in a plea seeking a stay on the demolition of 10,000 houses that has been planned by the Municipal Corporation of Faridabad at Koregaon in Faridabad, Haryana. A bench headed by Justice A.M. Khanvilkar heard the plea, which is filed by 10,000 families living in Koregaon who had challenged the Haryana Shehri Vikas Pradhikaran rehabilitation policy to the extent that it limited the cutoff for rehabilitation to 2003. The court further directed the DCP of Faridabad to provide police protection to the corporation officials. The Supreme Court took objection to grant of parole to a UAPA convict by the High Court of Rajasthan when the SLP was still pending before the Apex Court. A division bench of Justices Indira Banerjee and M.R. Shah made the observation while hearing an application filed by UAPA convict Arun Kumar Jain, who is presently lodged in Central Jail, Jodhpur, seeking grant of bail for 3 months on ground of his father's health. While refusing to entertain the bail plea, the bench also hauled up the applicant for approaching the High Court for parole when his special leave petition was pending before the Supreme Court. A petition under Article 227 of the Constitution is maintainable to seek the quashing of proceedings under the Domestic Violence Act, the Madras High Court has held. A single bench of Justice G.R. Swaminathan observed that Article 227 is forum neutral, which makes no distinction between civil and criminal courts. In other words, the power under Article 227 can be exercised both over civil as well as criminal courts. The bench was considering a petition filed under Article 227 of the Constitution seeking to quash proceedings instituted under the Domestic Violence Act. The registry of the court refused to number the petition, saying that the petition under Article 227 was not maintainable. The Delhi High Court dismissed an application seeking the postponement of the Foreign Medical Graduate Exam 2021 on an application moved by the Association of MD Physicians, also known as the Medical Council of India Screening Test. FMGE is a licensure examination conducted by the National Board of Examination in India as a mandatory requirement for an Indian citizen who has a medical degree from a college outside India to practice medicine in the country. The exam is scheduled to be held on June 18th. The Karnataka High Court has dismissed the writ petitions filed by e-commerce giants Amazon and Flipkart, challenging an order passed by the Competition Commission of India for a preliminary investigation into their alleged anti-competitive practices. A single bench of Justice P.S. Dinesh Kumar dismissed the writ petition, citing the limitations of the power of judicial review under Article 226 of the Constitution to interfere with a probe ordered by an expert specialized body. The impugned order was passed by the CCI in January 2020 under Section 26(1) of the Competition Act, directing the Director General to investigate into the allegations against Amazon and Flipkart. In a significant observation, the Allahabad High Court on June 10th observed that the disregard shown by the senior-most officials to the orders passed by the court has grave consequences on the rule of law in the country. In this case, a first information report had been lodged against the applicant under Section 394 IPC, and the bail application of the applicant was rejected by the Special Judge, Dacoity Affected Area, Oraya, on March 2nd, 2021. The AGA could not satisfactorily dispute the submissions from the record, and he stated that he did not have any instructions from the police authorities, who failed to provide instructions despite ample time being given for the same. The bench of Justice Ajay Bhanot further remarked that it has repeatedly noticed the failure of police authorities to provide instructions to the learned government advocate of bail applications from time to time. A division bench of the Bombay High Court has delivered a split verdict on the constitutionality of Section 13(8)(b) of the IGST Act, which imposes GST liability on services provided by intermediaries to persons located outside India. While Justice Ujjal Bhuyan has held the provision to be unconstitutional, Justice Abhay Ahuja dissented. Justice Ahuja said that he will release a separate opinion on June 16th, recording his reasons for disagreement with Justice Bhuyan. Those were the top stories from last week. If you wish to stay updated about the latest judgments, do subscribe to LiveLaw and don't forget to click the bell icon. I am Taniya Pandey. I'll see you again next week. Until then, take care of yourselves and stay healthy and happy.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.